अब मैं वो एग्जांपल्स दे रही हूँ जिसमें अरविंद केजरीवाल जी और उनकी पार्टी के जो अन्य सदस्य हैं उनको पहली तारीख पर बिना दूसरी पार्टी को सुने इस कोर्ट ने जो रिलीफ्स, जो प्रेमा फेसाई ओपिनियन और जो स्टे दिए हैं, आई विल गिव यू दोज एग्जांपल्स. Still, they wanted the case to be transferred, not because I was biased, but because they have apprehension in their mind that I may be biased. Uncontroversial and easy, but a reputation once surrendered by a judge. On examples of prima facie observations and interim relief granted in favor of respondent number 18, Arvind Kejriwal, मैंने पहली तारीख पर prima facie observations क्यों दिए? उसके examples. It will be appropriate to set out some instances where either the applicant Arvind Kejriwal herein or other leaders belonging to his political party were granted interim relief and stay by this court on the very first date itself without hearing the other side or calling for the reply, and such interim orders continue to operate till now. अब मैं वो एग्जांपल्स दे रही हूँ जिसमें अरविंद केजरीवाल जी और उनकी पार्टी के जो अन्य सदस्य हैं उनको पहली तारीख पर बिना दूसरी पार्टी को सुने इस कोर्ट ने जो रिलीफ्स, जो प्रेमा फेसाई ओपिनियन और जो स्टे दिए हैं, आई विल गिव यू दोज एग्जांपल्स. In the case of Arvind Kejriwal and another, the petitioners therein, who are applicants, respondents Shri Arvind Kejriwal and Shri Manish Sisodia before this court in the present proceedings, had challenged a summoning order. In that matter, the coordinate bench had stayed the operation of the impugned summoning order on the very same date of hearing itself, when neither the complainant nor his counsel were present before the court, and thus without hearing the other side. The said interim order continues to operate till date for about 6 years. However, the petitioners therein have no grievance with that interim order, even though relief was granted to them on the very first date without hearing the complainant, perhaps because the order was passed in their favor. The said matter was last listed before this court, this judge, when it was adjourned to 14th of July 26 at the request, and it was this court, this judge only, which had extended the interim order of stay, which was ex parte in favor of Shri Arvind Kejriwal and others. Similarly, in Raghav Chadda versus others, were two petitions filed by members, leaders of the same political party, of which Shri Arvind Kejriwal is the national convener. In those matters, summons had been issued to the petitioners in the complaint cases of defamation filed by members of another political party. In the said petitions, this court, in the interest of justice, had directed the trial court to adjourn the matter to a date beyond the date fixed before this court, and the interim relief granted in favor of the petitioner was allowed to continue. This was done even though no arguments were heard on the merits of the case due to paucity of time, which was specifically recorded in the order itself. No allegation of any bias or any ideological inclination was voiced at that time against the court by any of the parties. The petitioners in those cases who belonged to the political party of the applicant Shri Arvind Kejriwal also never argued that no interim order should be passed in their favor without first hearing the other side. Notably, the interim order has been operating in favor of the petitioners therein for last more than 2 years in this case. There are several other matters pending adjudication on the board of this court within MP MLA category, including cases filed by leaders belonging to the political party of the applicant Shri Arvind Kejriwal, where interim orders were granted in their favor on the very first day of hearing after recording their submissions, detail expressing prima facie view, even in the absence of the opposite party. Many such interim orders have been continued by this court, by this judge, but no allegation has been leveled in those cases, perhaps because those orders were in their favor. Be that as it may, these two examples have been discussed only to show that passing interim orders or recording prima facie observations at the initial stage, even in the absence of opposite party, is neither unusual nor indicative of bias. It is settled law. When urgency exists, the court finds that the matter requires consideration. Interim relief may be granted after recording the submissions made and forming a prima facie view, a judicial practice which is accepted without objection when it operates in one's favor cannot suddenly become a ground of bias when the same course is adopted in another case by a court of law. While I began to pen this judgment in the quiet aftermath of end of arguments, the courtroom had fallen silent, the voices of arguments had faded. The echoes of accusations no longer filled the courtroom or my ears. What remained was the quiet weight of responsibility of being a judge. who had taken oath on the Constitution of India, that is Bharat, to uphold the purity and dignity of the judicial system with one persistent question: should I recuse? It was also that moment when I realized that my silence as a judge itself is being put to test. And now, the question is no longer about the case, but about the judge and the fairness of the process and the institution itself. While in my entire life, as in the lives of many of my brother and sister judges across this country, the cases put up before us for adjudication test our knowledge, intellect, and experience. At times, before few of us, a litigant, through a case, tests the institution's resilience itself. This case belongs to the latter category. The challenge before me was not that I had to adjudicate difficult questions of law or fact, but I was drawn to adjudicate a recusal application against myself. However, it is not for the first time that such an application has been filed before the same judge seeking recusal by a litigant. Therefore, in that sense, it is not extraordinary situation for a judge. In the past, before this High Court itself, there have been multiple occasions when applications for recusal have been filed before the same judge, which have been heard and decided by them. The issue before me was clear as to whether I should recuse from hearing the present case. I was thus faced with a situation where my impartiality and dignity had been challenged, and the natural instinct would have been to recuse without hearing the application seeking recusal, which would have been the easier path of withdrawing and stepping aside. However, for the sake of institution, I decided to adjudicate the recusal application, for it throws questions not only at me, but also at the institution itself. It also weighed in my mind that all my brother and sister judges and the judges of district courts of Delhi, who are part of this institution, may be affected by the outcome of this application, since it may be cited as a precedent and many other litigants may take a similar course. Equally, was it clear to me that I had to decide it totally undisturbed and unaffected by accusations and insinuations in a fair manner, as objectively as it is required of a judge, and to test the recusal applications purely on the basis of jurisprudence of recusal laid down till date in our country. For that is what I have been trained to do as a judge and what I have lived in the 34 years of my judicial career. During arguments, the applicants repeatedly submitted before me that they do not doubt my integrity on any account, and they are seeking recusal not because they doubt my integrity, but because of apprehension in their own minds that I may be biased. What is also important is the fact that today I am dealing with an apprehension in the mind of the litigant and not actual bias in myself, which needed a thorough examination. What made my task very difficult and challenging was that during arguments, contrary stands were taken. All the applicants at the beginning of the arguments on recusal, and some in the pleadings as well, submitted before this court that they have complete respect for this court as an individual judge, and they do not doubt integrity of any kind or fairness of this court. However, still they wanted the case to be transferred, not because I was biased, but because they have apprehension in their mind that I may be biased. I am fully conscious of the fact that today I am not to judge the litigant, but the litigant has put me and this institution on trial. And it will be dealt with as it should be, not only on my behalf, but on behalf of the institution of judiciary itself. To reiterate, though choosing the path of recusal without even hearing the application for recusal would have been quiet, comfortable, uncontroversial, and easy, but a reputation once surrendered by a judge to accusations of bias, if not dealt with, will be very difficult to reclaim. Therefore, I choose the path to resolve the controversy thrown at me where my integrity has been put to test. The strength of judicial institution lies in strong resolve to respond appropriately to such accusations fearlessly and unhesitatingly. It is with this resolve that I begin writing my judgment in an objective manner without being affected by any of it. Now I am giving my brief observations, though not all. On examples of prima facie observations, an interim relief granted in favor of respondent number 18, Arvind Kejriwal, and members of his political party. The argument of recusal applicants have stated that merely because this court had granted limited interim relief on the first date of hearing and recorded certain prima facie observations, an apprehension has crept in his mind that I may be biased.